Here's where we're at, Ms. Lyons. Like it or not, you and I are in a long-term relationship. First time I had any dealings with you was back in 2013, and I had the opportunity during our hearing here. I mean, I take really good notes. I look back, I mean, I have 30 pages of notes on you, and I look back through my notes, and they are pretty much the same. Steal, probation, steal, repeat. That's how it works. I think I told you this at the sentencing. This is just a punishment case. This is not about giving you opportunities to improve or to show me that you've done. This is just a good old-fashioned punishment case because you continue to do the same sorts of things and you don't change your behavior. And as a result of that, I have to be the one that vindicates the system and says that there is a punishment for that crime. That's where we're at sentencing and for a final violation hearing. And the court had already found that Ms. Lyons has violated the terms of her supervision. Mr. View, on behalf of the state.
Your Honor, for the record, we have been in contact with the victims for the new 2025 case. The charges to the credit card have been covered for them. There was no request for restitution for that. They did not submit a victim impact statement, but did express to Ms. Kennard that their position was what they knew of Ms. Lyons' criminal history and involvement, that they did believe that incarceration was the appropriate sentence for the case, and they asked that the court to impose incarceration. And in terms of the state's recommendation, the court is well aware of Ms. Lyons' continuing criminal involvement for many, many years, for decades, frankly. Always been involved in theft-related offenses. She's been in front of this court, has sent her to prison twice for failures to comply with community control sanctions. As part of theft-related offenses, the new offense in this case includes with it a factual finding of multiple prior felony theft offenses within the recent time frame. She was on supervision at the time of the offense, so I think the court's well aware that Ms. Lyons is not a good candidate for community control. She cannot be supervised, and I believe probation's position would agree with me on that she is just incapable of following rules set by the court. Given those facts, I do think that a prison sentence is appropriate and warranted in the case. State's recommendation, given her extensive prior criminal history, is an 18-month prison sentence on the new charge. I do recommend that her probation also be revoked on the 2025 case, and that those sentences be ordered to be served consecutively.
For the record, I have read the pre-sentence investigation report and have discussed with the court and the prosecutor the different perspectives involved in the case. I would like to highlight, though, that Kimberly is doing construction work now, has been doing it full time, so she did have something, pardon the pun, constructive or wholesome going on in her life. She tells me she's been, her head had been cleaned 6 months, and that she feels that drugs have been at the root of her problems. I know her problems with the law go back some time, but she does feel that substance abuse has had some influence or impact upon that. She's been clean and sober for some time. She tells me she's been participating in AA, goes twice a week, and her sponsor is also president of the club, or AA unit or chapter. His name is Mark Akers, A-K-E-R-S, and she also tells me she's been attending church once a week. She would like to allocute on her own behalf, and she does have some supporters here, family members and friends who would like to speak at the appropriate time.
Ms. Lyons, what do you want to tell me?
I accept full accountability for my behaviors, and it was old behaviors. You know, the AA Big Book talks about, you know, you'll see the miracles start, the promises coming true before you're halfway through. Sometimes quickly, sometimes slowly. I'm healing from the wreckage of the past. and I'm trying to get it all behind me. I was 6 months clean when I got these new charges that I take full accountability for, that I feel horrible for, that I regret. I've made every positive effort in my life to do well. I'm very involved in my family, my sobriety, my recovery. I put God first in everything I do. And I know that I have a lot of wreckage from the past to clean up. And I'm finally free from that. The old behaviors took a little longer, but I've been working on those as well. I make constructive choices now. I had to write some stuff down because I get nervous and I don't know what I wanted to say. My old behaviors have been replaced with new ideas and healthy boundaries. Those old behaviors are no longer a part of my pattern. And I do ask the court to show mercy today so that I may continue to be a productive member of society that I am becoming more every day. I ask for mercy and understanding that I am cleaning up the wreckage of my past with full accountability, and just want to put it all behind me that I may go forward rather than backward. I'm pleading with the mercy of the court to deem whatever necessary probation intensity rather than incarceration to allow me to continue to grow and not wilt. And I ask this with humbleness and gratitude because I'm in the middle of a miracle. I've got a grandson.
Help me understand, Ms. Lyons. You're on supervision to me for committing a theft offense that you took a cell phone from Miami Valley Gaming. You're on probation for that. You took very little accountability for that at the time. You pled no contest, didn't really seem like you were taking much accountability for that back in 25 when it happened. That you would pick up a wallet and use the credit card. Explain to me how that happens.
You know, it was a very poor decision that I take full accountability for.
You keep saying full accountability. What do you mean by full accountability, Ms. Lyons?
I did what they said I did, and I'm sorry for that. And I knew it was wrong, and I regretted it immediately. And I'm making better choices now. And I feel confident that the life I'm living now, you won't see any of those kind of choices out of me again. I make conscious efforts and hard work every day to be a better person than I was before. And the prosecutor was right for decades, and it was drug-related, that I continued to have those kind of charges. And when I say I'm trying to clean up my side of the street and clean up the wreckage from my past to get it behind me, I mean that. And I've come a long way. I was 3 decades of those kind of behaviors. And it's kind of slowly, you know, my mind slowly healed. I did a lot of significant brain damage through the years of addiction, and it took me time to heal. And I'm healing. And this charge was 6 months ago. That doesn't matter, because what I did was wrong. But I'm making every effort every day to be a better person. I work, I'm involved in my family. I put my recovery and God first in my family. I make conscious effort to make better decisions. And I just want to move forward and get it behind me. If I have to be on probation for 10 years, I'll successfully do it.
Ms. Lyons, I can't supervise you. I mean, I get what you're saying, that you want to make better choices, but you don't. You make the same choice that you have been making since 2013. I have 29 pages of notes regarding you. And most of those 29 pages are the same thing. You taking something that doesn't belong to you, whether it be somebody's credit card, somebody's phone, somebody's information. Let's put aside the $100 bill at Dairy Queen that was sort of a one-off. But you're making the same mistakes, doing the same thing that you've been doing all the time. I'm going to sentence you to 9 months in prison on each of these. Those are going to be served consecutively because I think consecutive sentences are necessary to properly punish you, to protect the public based upon your criminal history. The overall sentence is not disproportionate to the conduct involved here or the danger posed by you. And I'm going to give you credit for the 63 days that you have already done. I'm not going to impose a fine. I am going to impose the costs. Is there anything else we need to do? Anything that I forgot?
No, Your Honor.
Ms. Lyons, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they will all be provided to you at no charge. You are remanded to the custody of the county sheriff pending transport to the facility. Good luck to you, Ms. Lyons.
Thank you, Your Honor.
Go ahead, trot your ass on out of here, go ahead.
I've got a monitor on my charger.
We're here today for a hearing on the motion for judicial release. Mr. Sims, it's your motion. You can remain seated if you want.
Okay. Your Honor, if moving forward, good afternoon, first of all.
Good afternoon.
I would indicate to the court that I had an opportunity to become acquainted with Miss Lyons and her mother and her family. As a result of that, I spoke with her mother, and we've come forward with a motion for judicial release. But the motion for judicial release is based upon the idea and the concept that we believe that justice would better be served with her being out under probation with a commitment to do better. Since she's been incarcerated, she's completed at least 13 different programs, which she has certificates for, which I have a copy of. I provided to the prosecution.
Ms. Groko, can you grab our exhibits there?
And in the process of completing those certificates, she certainly has shown a desire to improve herself and to understand the necessity of operating within the bounds of the law. We also have her sponsor here because there was at some point drug and alcohol issues, which she has addressed significantly, which is also indicated as part of the certificates that we provided to the court today. In addition, we have found employment available for her if the court determines that it's appropriate to release her at this time. It appears that she was incarcerated on 6/4/26 in the Department of Rehabilitations. She was sentenced to 90 days on each charge. She was given a credit for 70 days of jail time on case number, the original theft, which I believe was a 5th degree, and it's case number 25 CRA 2875. It appears as of today she served approximately 124 days in incarceration, which is less the 9 months on each charge that she was originally incarcerated on. At this point, I think Ms. Lyons' position is that in order for her to become fully rehabilitated, it's advantageous for the state, it's advantageous for the public because she's no longer a threat to the public. In order for her to achieve her potential and lessen the blow of hardship on her granddaughters who she helps take care of in order to be released today.
You don't have to get up. You can sit down. We're fine.
I just want to thank you for this opportunity today, and I want you to know I'm fully committed I'm unshakable in my commitment to not be before you again. I will successfully complete a judicial probation. I did something in prison every day to better myself and improve myself. And as you see with the certificates, I also didn't get any in trouble, did not get any tickets in prison or anything like that either. I'm fully committed to bettering myself moving forward. Thank you for this opportunity.
Mr. Dean, anything from the state?
Your Honor, as the court's aware, the state is opposed to judicial release. The court is very familiar with Ms. Lyons and her criminal history. She has 21 prior misdemeanor and felony theft-related offenses dating back until from the early 90s. She's had multiple incarcerations in prison, has failed to correct her behavior. She's had multiple opportunities for probation sanctions, for classes, for treatment. Again, none of those have impacted her behavior. She's had multiple prior revocations and violations, and many, as is in this case, those violations were in fact new theft offenses. So as the court's aware, in this case, she was on supervision for a theft offense when she committed the new felony theft offense that resulted in the prison sentence and revocation. In the current case, in the state's opinion, she is not a good candidate for community control. I think she's adequately demonstrated that in nearly 30 years of criminal history, and we ask that she just be ordered to serve the remainder of her sentence.
Ms. Lyons, I'll give you the last word in this. Is there anything else that you would like to tell me?
I did try really hard to address my old behaviors. The 30 years of history I had came along with 30 years of addiction issues and old behaviors. The old behaviors took a little longer to correct than the addiction itself. I'm probably most passionate about the certificate I got for peer support. I've got one heck of a testimony in helping other people on the other side of this. And I did take a course in critical thinking and thinking for a change as well. I did complete my 12 steps again through online. I took several classes in the line of work I do. I've got full-time employment. I've got a brand new grandson at home I haven't met. I can be successful for the first time in my life, and we really appreciate this opportunity.
Here's where we're at. Ms. Lyons, like it or not, you and I are in a long-term relationship. First time I had any dealings with you was back in 2013, and I had the opportunity during our hearing here. I take really good notes. I look back, I have 30 pages of notes on you, and I look back through my notes, and they are pretty much the same. Steal, probation, steal, repeat. That's how it works. And I think sometimes there's this misunderstanding, Ms. Lyons, that you can't do all of the things that you are talking about doing without me ordering them. You can go to treatment and treatment not be ordered. You can get a sponsor and me not order it. You can get into a sober living place and me not order. All of those can happen without me having to order it as part of probation. But I think I told you this at the sentencing. This is just a punishment case. This is not about giving you opportunities to improve or to show me that you've done. This is just a good old-fashioned punishment case because you continue to do the same sorts of things and you don't change your behavior. As a result of that, I have to be the one that vindicates the system and says that there is a punishment for that crime. That's where we're at now. I hope that you are able to continue all of the progress that you have made, but it's going to have to wait until you get out. I am going to deny your motion for judicial release. If you and the prison are able to work out something for transitional control or something like that, I'm not gonna stand in the way of that if they ask me about it, but it doesn't make any sense for us to supervise you, Ms. Lyons. Good luck to you.
Thanks for granting us a hearing, Your Honor.
You're welcome.